Noah Feldman is the Felix Frankfurter Professor of Law at Harvard Law School. Professor Feldman has authored 7 books, including a biography of James Madison and a constitutional law casebook, as well as many essays and articles on constitutional subjects. Professor Feldman received his undergraduate degree from Harvard College, a Doctor of Philosophy from Oxford University, where he was also a Rhodes Scholar, and a J.D. from Yale Law School. He also served as a law clerk to Justice David Souter of the United States Supreme Court. Now, if you would please rise, I will begin by swearing you in. Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show the witnesses answered in the affirmative. Thank you, and please be seated.
Mr. Chairman and members of the committee, thank you very much for the opportunity to appear. My name is Noah Feldman. I serve as the Felix Frankfurter Professor of Law at the Harvard Law School.
I seek recognition for privilege motion.
My job is to study and to teach the Constitution from its origins until the present. I'm here today to describe 3 things: why the framers of our Constitution included a provision for the impeachment of the President, what that provision providing for impeachment for high crimes and misdemeanors means, and last, how it applies to the question before you and before the American people, whether President Trump has committed impeachable offenses under the Constitution. Let me begin by stating my conclusions. The framers provided for the impeachment of the President because they feared that the President might abuse the power of his office for personal benefit, to corrupt the electoral process and ensure his re-election, or to subvert the national security of the United States. High crimes and misdemeanors are abuses of power and of public trust connected to the office of the presidency. On the basis of the testimony and the evidence before the House, President Trump has committed impeachable high crimes and misdemeanors by corruptly abusing the office of the presidency. Specifically, President Trump has abused his office by corruptly soliciting President Volodymyr Zelensky of Ukraine to announce investigations of his political rivals in order to gain personal advantage, including in the 2020 presidential election. Let me begin now with the question of why the framers provided for impeachment in the first place. The framers borrowed the concept of impeachment from England, but with one enormous difference. The House of Commons and the House of Lords could use impeachment in order to limit the ministers of the king, but they could not impeach the king, and in that sense, the king was above the law. In stark contrast, the framers, from the very outset of the Constitutional Convention in 1787, made it crystal clear that the president would be subject to impeachment in order to demonstrate that the president was subordinate to the law. If you will, I would like you to think now about a specific date in the Constitutional Convention, July 20th, 1787. It was the middle of a long, hot summer, and on that day, 2 members of the Constitutional Convention actually moved to take out the impeachment provision from the draft Constitution. And they had a reason for that, and their reason was, they said, well, the president will have to stand for re-election. And if the president has to stand for re-election, that is enough. We don't need a separate provision for impeachment. When that proposal was made, significant disagreement ensued. The governor of North Carolina, a man called William Davey, immediately said, if the president cannot be impeached, quote, he will spare no efforts or means whatever to get himself re-elected. Following Davey, George Mason of Virginia, a fierce Republican critic of executive power, said, no point is more important than that impeachment be included in the Constitution. Shall any man be above justice, he asked, thus expressing the core concern that the president must be subordinate to the law and not above the law. James Madison, the principal draftsman of the US Constitution, then spoke up. He said it was, quote, indispensable that some provision be made for impeachment. Why? because he explained standing for re-election was, quote, not a sufficient security, close quote, against presidential misconduct or corruption. A president, he said, might betray his trust to foreign powers. A president who, in a corrupt fashion, abused the office of the presidency, said James Madison, quote, might be fatal to the republic, close quote. And then a remarkable thing happened in the convention. Gouverneur Morris of Pennsylvania, one of the two people who had introduced the motion to eliminate impeachment from the Constitution, got up and actually said the words, I was wrong. He told the other framers present that he had changed his mind on the basis of the debate on July 20th, and that it was now his opinion that in order to avoid corruption of the electoral process, a president would have to be subject to impeachment regardless of the availability of a further election. The upshot of this debate is that the framers kept impeachment in the Constitution specifically in order to protect against the abuse of office with the capacity to corrupt the electoral process or lead to personal gain. Now, turning to the language of the Constitution, the framers used the words high crimes and misdemeanors to describe those forms of action that they considered impeachable. These were not vague or abstract terms to the framers. High crimes and misdemeanors was the words high crimes and misdemeanors represented very specific language that was well understood by the entire generation of the framers. Indeed, they were borrowed from an impeachment trial in England that was taking place as the framers were speaking, which was referred to, in fact, by George Mason. The words high crimes and misdemeanors refer to abuse of the office of the presidency for personal advantage, or to corrupt the electoral process, or to subvert the national security of the United States. There's no mystery about the words high crimes and misdemeanors. The word high modifies both crimes and misdemeanors, so they're both high. And high means connected to the office of the presidency, connected to office. The classic form that was familiar to the framers was the abuse of office for personal gain or advantage. And when the framers specifically named bribery as a high crime and misdemeanor, they were naming one particular version of this abuse of office, the abuse of office for personal or individual gain. The other forms of abuse of office to affect elections, and abuse of office to compromise national security, were further forms that were familiar to the framers. Now, how does this language of high crimes and misdemeanors apply to President Trump's alleged conduct? Let me be clear. The Constitution gives the House of Representatives, that is, the members of this committee and the other members of the House, quote, sole power of impeachment. It's not my responsibility or my job to determine the credibility of the witnesses who appeared before the House thus far. That is your constitutional responsibility. My comments will, therefore, follow my role, which is to describe and apply the meaning of impeachable offenses to the facts described by the testimony and evidence before the House. President Trump's conduct, as described in the testimony and evidence, clearly constitutes impeachable high crimes and misdemeanors under the Constitution. In particular, the memorandum and other testimony relating to the July 25th, 2019 phone call between the two presidents, President Trump and President Zelensky, more than sufficiently indicates that President Trump abused his office by soliciting the president of Ukraine to investigate his political rivals in order to gain personal political advantage, including in relation to the 2020 election. Again, the words abuse of office are not mystical or magical. They are very clear. The abuse of office occurs when the president uses a feature of his power, the awesome power of his office, not to serve the interests of the American public, but to serve his personal, individual, partisan, electoral interests. That is what the evidence before the House indicates. Finally, let me be clear that on its own, soliciting the leader of a foreign government in order to announce investigations of political rivals and perform those investigations would constitute a high crime and misdemeanor. But the House also has evidence before it that the President committed 2 further acts that also qualify as high crimes and misdemeanors. In particular, the House heard evidence that the President placed a hold on critical U.S. aid to Ukraine and conditioned its release on announcement of the investigations of the Bidens and of the discredited CrowdStrike conspiracy theory. Furthermore, the House also heard evidence that the President conditioned a White House visit desperately sought by the Ukrainian President on announcement of the investigations. Both of these acts constitute impeachable high crimes and misdemeanors under the Constitution. They each encapsulate the framers' worry that the President of the United States would take any means whatever to ensure his reelection. And that is the reason that the framers provided for impeachment in a case like this one.